Hey there, I'm Felicia from Buy Your Land for Cash. If you feel stuck with an unwanted property, call or text us. We'll get you a no obligation cash offer for your land and see how we can help you out. In today's land blog video, we're going to look at what documents do you really need to sell land. There are several documents that are required to complete the transaction. Quick note, when selling land for sale by owner, you're typically going to need to provide the same documentation as if you were working with a real estate agent. The difference is when you're doing for sale by owner, you do the work. On all the papers, all the documents, make sure they're legally binding. You're doing all the work that an agent would normally do. So the documents can vary depending on the location and specific circumstances, but some common documents include a current survey of the property. This is going to show the boundaries, dimensions, and any improvements. Property title or deed. This is going to prove the ownership of the land and will be necessary to transfer ownership to the next buyer. Zoning and land use documents will show if the land is zoned for the intended use and that it complies with local regulations. Environmental reports. These will show if the land has any known environmental hazards or issues that might impact the value or use. Building permits and inspections. If any structures or improvements have been made on the land, you may need to provide proof that they were built legally and comply with local building codes. Tax statements. You may need to provide proof of payment of current and past taxes on the property. Disclosure statement, and that lists any known issues or defects of the property that may affect its value. Death certificate, which is a legal document issued by a government agency, typically a health department or a stats office that certifies the fact of the person's death. This might be required in situations where a property is inherited following the death of the previous owner. Affidavit, which is a written statement that is sworn to be affirmed to be true. A document that's used to prove a fact or a situation and can prove various facts about the property. Some states do require an affidavit to be provided by the seller as part of the sales process. Others don't, okay? It depends. It's really important that you consult with a local real estate attorney to make sure that you have all the necessary documents and that the sale is in compliance with local and state laws. Additionally, it's important to be aware that if you are selling it by owner, so that's you are doing the work, you will be responsible for advertising, showing the property, negotiating the sale, coming up with all the paperwork. So it's really important to be familiar with the local real estate process and laws in your area. That's a big list of laundry, right? And truthfully, you don't need all those documents to sell land. It really comes down, in our experience, to a few crucial ones. Purchase agreement, proof of ownership, and deed. A purchase agreement, also known as a sales contract or a purchase contract, is a legally binding document that outlines the terms and conditions of a real estate transaction between a buyer and a seller. It's a written agreement that specifies the price, closing date, and other important details of the sale. A purchase agreement typically includes things like a legal description, the names of the buyer and seller, the purchase price, terms of payment, closing date, location, any contingencies that must be met before the sale can be completed, any representations made by the seller, a disclosure notices required by the law, and of course the date of the agreement. It's important to note that purchase agreements are legally binding and should be reviewed by an attorney before signing. Once both parties sign the purchase agreement, it becomes a legally binding contract, and the terms outlined in the agreement must be fulfilled by both parties. It's also important to note that purchase agreements may be different in each state, so it's important to understand the specific requirements and regulations of the state where the property is located. Second one is proof of ownership. That comes in the form of a land title, also known as a property title or property deed. It's a legal document that proves ownership of a piece of real estate. It includes a description of the property, the name of the current and past owners, and any liens or encumbrances out on the property. The land title is the official record of ownership for a piece of property, and it's recorded with the local government, that's at the county offices. It's considered as the evidence of ownership of the property. The title is typically held by the owner in fee simple, which means the owner has the right to use, possess, and dispose of the property. The title also contains information about any restrictions or easements on the property, such as right-of-way for a neighboring property or a zoning restriction that limits how the property can be used. Having a clear title means that there are no outstanding legal claims or liens against the property, and that the seller has the legal right to sell the property, and that's a big one. This ensures that the seller has the legal right to sell the property. To check the title of the property, make sure that chain is secure, a title search can be done. This is a process that checks public records, ensures the title is clear, and that the seller is the legal owner of the property. Highly recommended to have a title search done by a title company or an attorney before purchasing a property. That third crucial document is a deed. A deed is a legal document that you're going to use to transfer ownership from the grantor to the grantee. The deed will include a description of the property, names of current and past owners, and any liens or encumbrances out on the property. It's a written instrument that, when executed and delivered, conveys title to real property. The most common types of deeds are warranty deed, quitclaim, and special warranty. And they are all slightly different. Warranty deed is going to be the best one. Quitclaim deed, kind of want to avoid. It's normally used between friends, family, quick transfer. You don't really have any insurance against any breaks in the title chain or liens out against the property. So the deed must be signed, notarized, delivered to the buyer. Must also be recorded in the public records of the county where the property is located. This process is called the recording the deed. Recording the deed ensures that the new ownership is a matter of public record, which is very important, and it also gives notice to any other parties that may have an interest in the property. It's important to note that a deed alone doesn't prove ownership. It's the title that provides evidence of ownership. A deed is a way of transferring ownership, while a title is the actual evidence. So when selling vacant land, yes, there are a lot of documents that are nice to have, but the most essential are the purchase agreement, proof of ownership, and a deed. These are all legally binding and necessary to transfer the ownership of the property. It's important to ensure that the purchase agreement is reviewed by an attorney before signing, and that the property title is clear and the seller has a legal right to sell the property. I know that was a lot I just threw at you. If you want to skip all the paperwork and the headaches, my company, Buy Your Land for Cash, we buy land every day and we take care of all that work for you. If this is something that interests you, call or text us. We'll give you a no obligation cash offer on your land. If you have any questions, leave them in the comment below and I'll get back to you as quickly as possible. Don't forget to like and subscribe. That way you're the very first to know when a new land blog video comes out. Thank you so much for watching. I'll talk to you soon.